Another question from Sean: how to tell the difference between necessary sublicensing your IP, licensing your IP for product fulfillment versus giving them nearly full ownership versus actual assignment. Okay, so let me first of all just tell you what the word assignment means. When you do an assignment, you're basically stepping out of some kind of right or liability. So for example, if you were in college and you had a lease for an apartment, you were going to leave for a semester, you wanted to let someone else live there and take over the rent, you might have said that you were subletting it or subleasing it. What that means is that you're still the person on the lease and you're still responsible for everything, but for a little while you're giving your rights to somebody else. But maybe you're not planning on coming back to the apartment and you want out. You don't want to be responsible. You might still use the word subletting when you're talking about it, but the legal word that would be proper here is assignment. And so basically, you have the landlord, you have yourself, the original person responsible for the lease, and then you have a new person who's going to take over for you. When you sublet, you still stay in the chain of command. So the subletter pays you, you pay the landlord, and if anything goes wrong with and the landlord's unhappy, they're going to come to you. In an assignment, you are now no longer in the picture. It is now just you, the landlord, and the new tenant. So assignment, basically you step out and all of your rights and liabilities transfer to somebody else. So if you are assigning something to somebody, you're basically giving up your rights to it. So for example, you might assign your copyright to your work to somebody else. I helped a person who was elderly and they wanted to transfer all of their rights to some copyrightable thing, and so they did so. They assigned their copyright, and so therefore they no longer received royalties or had any say in it. So only do that on purpose. If you are simply sublicensing or causing someone to fulfill the work for you, so for example, they might manufacture it or ship it or market it for you, then you want to have a contract that basically limits what they're doing, and it should not have any rights of assignment. And so what you're going to do is you're going to give them limited permission, and so that's what sublicensing is. I've worked with open source software, and one of our next questions is going to be about open source software. But open source software typically has a license, like the very popular Apache license or the GNU GPL license. And so what this does is the people who create the software say, I'm going to give you right to use it, to copy it, to share it. That's how open source software works. You might not want to give them all of the rights. You might just say, I'm going to give you the right to make copies and to distribute those copies. So that would be okay. You might say, I'm going to give you only the right to publicly perform. That's what you need is you need a very clear, well-written, attorney-written agreement that says these parties have certain rights and that's it.